Good day, everyone. I'm your host, James Hicks from Hicks New Media, and welcome to our Lunch with a Lawyer Q&A series in collaboration with the Basile Law Firm. Each month, we engage with you, the community, and strive to help answer your questions around legal topics affecting the retail investment community. As this is a premium session, subscribers have priority to getting their questions answered. So go ahead right now, go ahead and click that subscribe button so you can get into the discussion. Get ready. We're going to have a great one, and I'll see you on the other side. There we are. Ladies and gentlemen, it's 2023, and I got Mr. Gus Pasanante on the line. It doesn't get any better than that. It gets no better than that. Sir, how are you, man?
Good, James. Good. Happy New Year. It's good seeing you.
You too. Listen, let's go ahead and get these flowers out of the way. Let's go and get these flowers out of the way. I'm a man of speaking things when they're just due. And first and foremost, congratulations, sir, on your new role. Congratulations for becoming partner at the firm. We knew it was going to happen. All I had to do was send Mark a couple of emails and say, "Come on now, let's go ahead and make this young man." Give him one of them corner rooms. Give him a refrigerator on his desk. No. No. Congratulations to you, though, man. Well deserved, just deserved.
Thank you, James. I appreciate it.
Awesome. We a lot of folks are jumping in. Thank you for the community for coming in. Again, as I was saying, this is a premium session, so we are going to give priority to those who are subscribers to the channel. We are live on LinkedIn. We are live on YouTube, obviously, and we are live on Twitter. So the folks on Twitter, just the looky-loos, they can't engage. So either jump on over to LinkedIn or jump over to YouTube. But let's go ahead and open it up to some conversations that what have you been working on from your perspective at the law firm that may resonate with the audience? What have you been seeing in these past few months? Don't know if it's been necessarily a slow time, if there is a slow time within your industry, but how would you like to start with a conversation about what's going on in not just the OTC market, but again, what the Basile Law Firm has been working on lately?
Yeah. So I think I want to talk about kind of legal precedent and the appeal process and the appellate process and how, what it means when a district court or a trial court decision is appealed by an appellant, what the process is, the ramifications, the potential outcomes, and things that could happen after a bad decision or a purported bad decision, as an appellant might put it. But just to start off, right, there's levels to courts, right? There's the trial court, which is where you file lawsuits. That's where facts are found. That's where you ask a jury to agree or disagree with your version of the story. That's where a judge decides on issues of law after facts are presented. That's where you get judgments. That's where basically a majority of court, quote unquote court, takes place in the majority of the public's eyes. Beyond that trial court or district court level, and also just as a precursor, there's obviously our court system in this country is bifurcated. We have federal courts and we have state courts. Just for context, I'm going to be talking generally. I'm not going to be talking about one or the other. Our practice is mainly takes place in federal district courts around the country. So most of my experience is in the federal courts as opposed to state courts, but state courts are more or less the same. Sometimes they're a little bit different. Sometimes the state courts have more courts with limited jurisdiction, and that means that they're kind of separated a little bit more as opposed to federal courts. Federal courts are very broad. Anything that goes into a federal court, there's just one federal district court. There's not a family court in federal court. There's not a business court or commercial court in federal court, as opposed to state courts, which might be kind of separated. but that's kind of in the weeds a little bit. But generally, I want to kind of talk about like the structure of our court system, right? So you have that trial court, that district court level, that first level where lawsuits are filed, judgments are received, opinions are written. After that, there's an appellate level, right? That appellate level is for district court litigants to appeal to if they feel the need to appeal. If the appellate decision isn't, if that appellate decision is also appealable, they can usually go one more level up. And of course, the higher you go, the more difficult it is to get an appellate court to hear your side of the story or hear why you think that the other court made an error, why the lower court made an error. And I want to also kind of be clear about what's appealable and what isn't. If you don't like a decision, you can't appeal it just because you don't like it, just because you didn't agree with the outcome, right? And there's three main ways you can appeal like a district court or a trial court's decision. You could appeal an incorrect decision of law. You can appeal an incorrect interpretation of fact, and you can also appeal a decision of discretion. All of those three types of appealable events, let's call them, or appealable actions that can be taken by a trial court judge, are reviewed in different standards. They have completely different standards of review, right? And I'll try and explain that a little bit more, but it could get a little bit complicated. So please just like cut me off and ask questions if you have any.
Yeah, definitely will.
So if the first one we'll talk about is a mistake of law, right? If a litigant feels like a judge made a mistake applying law, the standard review for that is something called de novo. And de novo is it's a Latin term. I forgot what it means exactly. I think it translates to something along the lines of like with fresh eyes or something. And what that means in short is just that appellate court is going to look at that decision that was written or granted or denied by that trial court judge. Is going to look at it with a clean slate. They're not looking at anything. They're basically looking at it for a second time, right? So let's say a motions to dismiss is filed. Motions to dismiss are generally reviewed de novo, because you're not majority of the time, at least in federal courts, you're not looking at facts in motions to dismiss, right? So those are reviewed de novo. The appellate court judge, that next level, is going to look at it as if they're the trial court judge. They're just going to look at it with a clean slate, and they're going to look at it, they're going to also probably look at it with a little bit, go through it with a fine tooth comb, look at it a little bit closer, take into account maybe more things than what a trial court might, because when you get into that appellate round, there may be more than just the parties submitting papers. There's something called amicus briefs or amicus curiae briefs or curiae. I'm not sure I pronounced that second part. And amicus is that's also another Latin term. It means a friend of the court, right? Okay. So in super highly debated, especially like political or like Supreme Court decisions, those appellate matters, when something goes to the Supreme Court, like a big hot constitutional topic, a bunch of amicus briefs are going to be filed by interested parties, let's call them, right? And they're considered friends of the court, and they want to also influence the court, the Supreme Court or that appellate court, to decide in a certain way, right? We've had appeals get filed in, for example, the Second Circuit in New York, and toxic lenders will file amicus briefs against us because they want to make sure that they win.
Against
right?
you, the law firm, as opposed to you, your client.
Well, against our client.
Okay.
Against our client, right? So they're opining, they're putting in their papers, and they're supporting a position, even though they have no interest in the outcome of that decision. Okay. Not directly, but indirectly, of course, because if that appellate court overturns, like they have before in the past for us, which they often do, because what we do is very complicated, and it's very niche, and it's often misconstrued or misinterpreted. They want to make sure that they can do everything they possibly can to get a favorable decision, so their other transactions are not affected by it, right? That's that first kind of standard review for mistakes of law. The next one, which is less common, are mistakes of fact. That's a very high standard of review. It's you need to show a clear error of law. So, for
Mm.
example, let's say it's a criminal case where somebody um, yeah, robs a store. There needs to be some kind of clear error where the fact finder just could not have possibly believed the facts to go a certain way. It's like if all the evidence leads to one thing, and then there is a clear, and when I mean clear, I'm trying to say that I'm trying to put a lot of emphasis on the word clear because it's a very high burden to meet. When there is a clear error of the facts, then you can overturn a factual mistake, right? That's made by a fact finder, which could be a judge or a jury, depending on the type of trial. If it went to a jury trial, or if it was if it was a bench trial where the judge found the facts, or a summary judgment motion where a jury wasn't invoked. And then the third type is something called an abuse of discretion. So those are on like discretionary motions. So, for example, injunctions are discretionary. Those are also very difficult to overturn, because in that scenario, you need to persuade that appellate court that the trial court judge abused his discretion. So, what the appellate court is analyzing in that situation, they're analyzing the trial court judge's um, discretion with what he had in front of him. So basically, they're looking at the trial court judge and they're saying, um, do we think that you should have made that decision with everything you had in front of you? And do we think that you abused the discretion that you had? Versus looking at it with like a clean slate, like such as like a de novo review for something like a motion to dismiss, by not taking into consideration the judge's record or what was put in front of the judge whatsoever. And in that scenario, it's like a clean slate. So those are all like the different levels of review. The way someone might get there is, of course, they get an unfavorable decision. The appellant will file a notice of appeal, and there's usually some ancillary paperwork that goes along with it, some like kind of brief but still formal, kind of, I guess, like explanatory material. It's not like a full motion, it's not like a brief, but you're kind of explaining the issues, you're explaining where the court made the mistakes, and where you think what should be reversed. In this scenario, this is also where the appellate court decides to even take your case or not. Because the appellate court doesn't have to take it. If they think that there was no error made, they won't listen to it. The Supreme Court is notorious for only accepting, like, I think it's less than 3% of all writs. It's called a writ of certiorari, I think that's how you pronounce it.
You
To
throwing
appeal
all
to the
these
Supreme
Latin terms out here. Listen, I'm barely good at English. Okay. Right.
Court.
You at the 201, 301 level already. Now you throwing Latin out. So, okay.
Sometimes it makes me feel better because I paid a lot of money to learn those Latin words. So I
Partner.
gotta use them
Partner.
somewhere. So, like, for example, the Supreme Court doesn't take many cases at all. Actually, I think it's less than 3%. I want to say it's like 1%, more like 1%. Um, the second level of appellate courts, they take more than 1%, but after that first level of appeal, it's even harder to get to that final level, that Supreme Court, or for example, in New York, the Court of Appeals, because New York likes to do things in a confusing way, and instead of making the Supreme Court the highest court, they make our Supreme Court the trial court, so it's like almost backwards. But that's just a kind of like a quick breakdown of that process.
Yeah.
When the appellant files a notice of appeal, the appellate court, if they choose to accept the issue on appeal and review it, they will set a briefing schedule. Parties will brief it just like a motion in the trial court, and they might want to hear oral arguments on it. Oral arguments are a little bit different than traditional hearings too. It's usually, for example, in a circuit court, in like the Second Circuit, you'll get a certain amount of time. The appellant will get a certain amount of time, let's say 10 minutes. The appellee will get a certain amount of time, which will be the same amount of time as the opening argument. which will also be 10 minutes. And then the appellant gets another bite at the apple to get one rebuttal too, generally, which is a lot shorter amount of time, which will be 2 or 4 minutes, a fraction of the image of that opening argument time frame or time reserved.
Got you.
So after that, if the appellate court decides that the trial court made an error, they will fix the error. Sometimes they could just reverse the decision. Sometimes they will overturn the decision and then remand it back to the trial court because there needs to be more facts. Because there are some scenarios there where even if the appellate court finds that there was a mistake of law made and they overturn that mistake of law, it's possible that that trial court didn't seek the right facts to make the proper decision too.
Got you.
Right.
Okay.
So sometimes it's not just like a reversal. Sometimes they're vacating that decision and now they're remanding it to find facts further consistent with that appellate decision or that appellate opinion.
Let me pause you right here. Because, and I want to keep going where you are, but I want to give some context because what you're telling us right now is that behind the scenes, right? It's a month in the life of what you do, what you and your team do. I would question, and I would ask before you move on is, what's the percentage of time that you are within this stage, right? What's the percentage of time of the cases and the sessions and the involvements in the clients and things like that you have to go to these different levels, that you have to go to the various appellate courts, or that you have to possibly be that 3% that goes in front of the three, right? How many instances of the clients that the firm has that you actually have to go to this depth, right? Because the layman, right, the folks on the outside, I see my dad here, he's saying hello, and listen, his favorite show on the world is Law and Order. In 60 minutes, he goes from crime happening to crime, investigation to being right. He sees all of this truncated in a 60-minute time frame with commercials. This is real life right now, folks. So again, I'm just wondering. That's why I said a month in the life as opposed to a day in life. What's the percentage of time that you and your colleagues get to this extreme?
Yeah, that's a tough question to answer. Only because it really depends. For example, I think we've discussed this before, that broker-dealer issue, that broker-dealer registration issue. In most courts in the country, they accept that as the law. In New York, they don't, for some reason.
Okay.
So, for example, every time we lose in New York, that's an appealable issue. The reason why we might not do it every single time is because it's expensive to undertake one of these appeals.
Gotcha.
And of course, no guarantee in any kind of outcome. But especially when there's a split in the circuits, it's called, when there are some circuits that are ruling one way and then there are other circuits ruling another way, that's something that's ripe for the Supreme Court to hear. So I wouldn't be surprised if in a few years, within the next couple of years, that this broker-dealer issue does go to the Supreme Court, because there's a split in the circuits right now. There are some circuits that take one approach and there are other circuits that take another approach. And there's a number of issues that are generally like this. There's almost always a split in circuits for something. But of course, the Supreme Court can't hear everything. So it's whatever they decide to take up on writ. If they think it's something important that needs to be clarified, these circuits need guidance, they're going to take it. If they decide that it's not an important issue and there's something more important, of course, when you're dealing with federal courts, there's probably something more important than these business issues. This statutory interpretation of the Exchange Act, right? There's constitutional law issues that they might want to make a priority, of course, right? That's what you see in the news. You don't really see these statutory interpretation issues from the Supreme Court, even though they do come up. It does happen. These circuit splits do get resolved by the Supreme Court. It's not very common, though. But back to your question as to the percentage, I wouldn't say it's a very large percentage. I've worked on only a few in my career, but it's unfortunately it's I would say I probably encounter these appeals more often than a lot of my colleagues and people that I might have graduated law school with, and I would imagine my colleagues that work within my firm would probably say the same with their among their friends. I wouldn't say it's very common to have to appeal as much as we do, but I think the nuances that we face because of the position our clients are in, because of the way that they are, generally extorted, the way that they are victimized, the way that the statutes and the laws in New York are written, and the way that the common law has interpreted a lot of these statutes, like the penal law. It takes a lot of arguing. It takes a lot of explanation and understanding to get to where we need to be. I
Gotcha.
always talk to ARBs, and I'm going to say it again. Mark was told no 18 times in the trial court, besides the only court, until the only court that mattered agreed. Because Mark knew he was right the whole. I mean, we know we're right the whole time. Like we know that we're right. It's very difficult to convey some of this information um, to these judges, especially with how nuanced this area of law is. And if you're not an expert in this area of law, it's going to be very difficult for someone to understand it. Even judges, even these judges that go to Yale, that go to Harvard, you have to understand, like, there's a lot on their plate as well. That they're not experts in everything. They're
Mm.
hearing constitutional law cases. They're hearing cases about domestic terrorism. They're hearing cases about Exchange Act violations. They're hearing cases about antitrust violations. They're hearing cases about everything under the sun. Like I said, you're not designated to an area when you're in federal court. You have to know everything. And if you
Wow.
don't know it, you have to learn it. And if you can't learn it, you might make a mistake. So it happens. These kind of mistakes happen. It's not that it never happens, but in the area that we're in, it's extremely difficult to convey, because it is a very nuanced law. The usury laws in New York are very, very complicated, but at least in the context that we litigate them, and there is this kind of really specific nuanced issue with using usury affirmatively, as opposed to defensively,
Mm.
especially for corporate.
Okay.
So the way that the law is written is very clear, but the way it functions in practice is not so clear.
And the interpretation thereof. Okay. Mm.
Yeah, which makes the interpretation difficult, because even though the words are pretty clear, in practice it just doesn't work that way. You know what I mean? Does that make sense? I'm
That's crystal
trying to
clear, actually, and I'm glad you went kind of into that detail about that.
yeah,
Okay.
yeah.
Awesome. Listen, we got a couple of questions, and the man's got the coolest screen name, real easy. Uh, have shareholders ever sued a law firm hired by a public company?
Shareholders sued a law firm hired by a public company. I'm not sure. I'm not sure if they would have standing, but be interesting to know or find out.
Okay, okay. And we kind of knew these questions would probably come because folks know Mr. Pazinante, they know there was a law firm, and we know a lot of folks in the community are asking because we start talking about appealing. So now, is one of the clients within the portfolio, is DPLS, is Dark Pulse appealing? Not sure if you can answer that question or not, or be, at the
Yeah, that's on the
35,000 foot
docket.
level.
We filed a notice of appeal 2 hours after the decision. We kind of had a feeling that um, and be careful with
Mm-hmm.
what I say, but uh, in our experience, there are, especially in Mark's experience, like I told you, I think it was 18 times he was told no, and then he was right, ended up being right, and a very recent decision that we just had um, was one of the judges that said no. So we kind of had a feeling where he might lie. Uh, so that's why we were, ready to go, and we, filed the notice of appeal immediately.
Got you. Got you. Like I said, I knew we knew there would be some questions about that, so I wanted to put that up there, and we see some more folks chiming in. So, Miss Val is here. Good to see you as always. Are companies' interest and investors' interest one and the same for a litigation firm? And then where do the obligations and loyalties draw a line? That's an interesting question. Well, Miss Val is
Yeah,
always asking good questions, so
yeah,
don't
yeah.
expect nothing less.
That's a good question. That is a good question. So of course, when an attorney is retained by a client, the attorney has a duty to obviously abide by the client's wishes, and can never go against the client's wishes. Sometimes clients are organizations, um, And organizations have shareholders, they have agents, they have employees, they have a lot of levels to them. But at the end of the day, the attorney's client is the organization. Um, and while it could be muddy and there could be scenarios where those interests might overlap, the only interest that the attorney has is in his client. Uh, so in a scenario where a company may be a client of an attorney, the only interest is the client's interests. Um, I hope that answers the question.
Awesome. So where, and again, treading the line and making sure that we don't cross any conversations that you can't get into. But are there next steps with the specific appeal that's in place right now? Because I'm peeking out of the corner of my eye and I'm seeing a ton of tweets coming into my DMs right now, again, asking more specifics about the appeals that you're in right now. Obviously, know that we can't go into that, but folks, again, if you want those questions to be on the screen, please jump over to YouTube or LinkedIn so you can put those questions in the comment area. Where are you now? Right? Are you still at the early investigative stage? Are you still at the I'm not going to assume. Let me ask. Where are you now within that appellate process?
Yeah, I'm not going to comment any further
Okay.
than what's on the docket.
Yeah.
The docket is pretty clear where we are. We filed a notice of appeal, and then we're going to be, pursuing the steps that follow.
Love it. Love it. Appreciate that. Right. Uh,
Yeah.
where the remaining pieces of the firm, right? I mean, we've talked about you looking at branching into some different aspects of litigation, doing some different types of services for your particular clients. How has that started to shape, right? So again, not being known just as the firm that does A, B, and C, as we've branched off into this new year, as the firm has grown in terms of seniority and folks becoming partner and doing different and focusing on different types of things. How has that evolution happened, right? Again, not just being known as the firm
Yeah.
that specializes in this, but being more of the generalist. Where are we now in terms of that evolution and that growth? Specifically, I'm
Yeah.
asking for companies who may be looking to, right, reach out to the Basile law firm.
For sure. We're growing. As I don't know if I ever told you this, James, but Mark was my professor.
Mm-hmm. Mm-hmm.
Uh, yeah, you did know that. So Mark was my professor.
I know all the
He hired.
stories. I
Yeah.
know stories that you don't think
So
I know.
yeah. So when I started, it was and shout out to Eric Benzenberg too. Eric Benzenberg also just made partner,
That's a good
and so did
dude
Mark.
too. Yeah, congratulations, Eric. That's a good dude.
Yeah, yeah, and Chris Basile as well.
Love it.
But so when I started, Chris wasn't even out of school yet. It was me, Mark, and Eric. It was us three. It was like the Three Musketeers. Um, we did everything. We from start to finish, and very shortly after that, we started to get really busy, and we needed to expand. I think we're up to somewhere around 10 attorneys, and then we have a few of counsel relationships, so we could provide those full service. We could be a full service boutique corporate firm to our clients. So we can keep intellectual property matters in house. We can keep tax matters in house. We can keep that corporate governance work in house. We're looking to expand into other areas that I won't comment on now, but we're looking to be a full service corporate boutique. We want to be able to give that big law firm service, but give you that small law firm comfort, and be able to have conversations and talk and get to know each other. I'm actually super proud to say I think I'm pretty close, and I think I'm friends with most of my clients at this point. Um, because that's just the kind of relationship that we like to foster. And
Yeah.
but at the same time, we also want to be full service. We want to be able to provide the services that those bigger firms provide, and make sure that we do it the right way, and make sure we continue to do that. So right now we're growing. We do have we are taking on some more transactional matters. And I'd say right now it's pretty much we have our transactional stuff and we have our litigation separated. And of course, when those odds and end matters, those tax matters, those IP matters, those smaller things, we do have those of counsel relationships to make sure that we can keep that stuff in house with our clients, and we can keep our clients happy, and we make sure that we can provide them whatever they need, whether it's myself or Eric or one of our of counsel relationships with some of the attorneys that are coming across the screen now. We're that's my goal at least, and that's as a firm we're making strides towards doing that.
I love it. I love it. Listen, and I can attest to it. I can speak to it. I saw it firsthand, folks. The team knows how to draw that hard line in the sand if necessary, right? I mean, and relationship is a good. So I'm not talking to you right now, Gus. I'm talking to everyone that's listening, right? They really are the professional liaison for the clients that I've seen them directly engage with, and we can go out, we can have breakfast, we can go out and have dinner. And then when it's time to flip the switch and it's time to talk business, man, I saw Gus turn into Jekyll and Hyde, right? I mean, it was no more, pass me the orange juice. It was let's get down to business. So and I love the engagement and the interaction between, and not gonna say the specific clients, right? But the clients that you were working with at that particular time, and how that trust in you from them was evident, right? And I had some personal conversations with those clients about that relationship, and it is 100% authentic. So again, giving you and Eric and of course the man with the name on the top of the building, right? Giving you your props and your flowers for sure. Um, Ms. Val is asking another great question. How do you measure a client satisfaction? That's a really interesting question, because that could be subjective, that could be objective, but what's that KPI, right? Of how you kind of evaluate and measure a client satisfaction.
Yeah, that's a really good question. I think that is a subjective kind of, I guess, decision that
Did you keep
we
them
have
out
to
of
make
jail?
as
That,
attorneys.
that kind of thing. Are they not going to jail? Yeah. Well, then it's a good relationship.
Right. um, but I think it's um, we never ask, "Are you satisfied?" Right? But we advise, and we always are, make sure that our lines are open, that if we're doing something that you're not happy with, make sure you let us know, and we're going to do whatever we need to do to fix it and make things better. um, and that's really our role, right? Like, we're not just attorneys, we're problem solvers. Like, if there's something
Mhm.
that's not right, we're going to fix it. And if it requires us to go to court and do it, then we're going to go to court and do it. If it requires us to do something out of court, something less formal, give advice or counsel, then that's how we're going to approach that situation. um, how to measure satisfaction, I think that's like you said, it's pretty subjective. I think that my clients, if they're not happy, they've definitely expressed that to me, and I'm very thankful and happy to say that it doesn't happen often, and I can't even think of many times that it ever has. um, the one something that happened recently that I think was pretty interesting to witness. I don't know. Are we breaking up, James? Are you can hear me?
No, no, we're good.
Looks like reason. Okay. Um, we were in the middle of a mediation. I'm not going to disclose what client this was. It was a couple of months ago, about 3 or 4 months ago. I might have mentioned this, but we're in the middle of a mediation. And the way mediations work is that there's a mediator um, that will go from one room, which is one party, like, or one side of the V, right, the plaintiffs, and then the mediator will go from that room to the other room, which is full of the defendant or defendants, right? So we never talk to the opposing party face to face, but there's this liaison that goes from room to room, and they try and make us agree, right? Because they're hearing all that confidential stuff, and they know what each of us want, what we can all stomach, what we can all walk away from. What we can all take away from a certain situation, and what they think is fair, and they're going to have like the best, uh, I guess the best. They're going to be in the best position to evaluate that and be able to influence the parties to
Mm.
make a good decision for themselves, right? And that's the goal of all settlements. I mean, in realistically, in every scenario, there's probably a number that's worth it for everyone, and that's always kept in mind. And I'm never, not never, but I traditionally go into settlements or mediations to discuss a mediation, to discuss a resolution, to try and get to that number, to work diligently with opposing counsel, with my own client, and say, hey, sometimes you got to cut off an arm to save the body. And sometimes people need to make those decisions, and it's difficult to make those decisions sometimes, but that's why we're there, to explain why it is or is not a good decision to do that. And in this mediation, I was explaining to the mediator, which in this scenario was a not super experienced in our area of law, but was a very good listener and was very good at understanding the issues at hand. Um, and I was articulating things, and the more I articulated, the less my client wanted to settle, because the more confidence he got in me throughout the mediation. And every time the judge or the mediator would walk out of the room, he'd say, "We're not settling." And I would have to talk him down and say, "I really appreciate all the confidence you have in me, and I appreciate that you're understanding and you really believe that I'm conveying, our position or your position to the judge or to the mediator. But in the same token, there is a number that might be worth it, that we should stomach, that is going to make sense for you, and sometimes it is worth cutting off an arm to save the body." But that made me feel good. It made me feel like, I really did something good. Like I'm trying to influence a resolution, and I'm doing the opposite because I'm doing such a good job for articulating a position. So that was a time where I thought I was satisfied.
Listen, man, every day you step in the courtroom, you come on. We know you hit it out the park, man. No, again, let's not be humble around here. We go way back, and we all appreciate the good work, and again the diligence that you provide all of your clients and your colleagues, right? Because again, you can't do it alone. It's a community, and again, when you gotta circle the wagons, and you got to get the whole squad together and roll up your sleeves, it's obviously that you're doing high caliber, high quality work. In this last 10, 15 minutes that we have, and folks can keep asking your questions. I see with this Cumia's last fan says, "You look like a great value Ben Affleck." I think that's a compliment.
I think so too.
Okay, I didn't want to put it on screen, but I'm gonna put it on in there anywhere since they. I think I don't know who. I'm gonna leave that there. Okay. Oh, see, now there you go, brother. Okay, see, now they come with the crazy comments, but that's all right. Shouts out to you too. We gonna go and let that slide. A lesson learned, or a thought that you would like to give folks that are focused, either vested financially or vested spiritually, emotionally, whatever way, in some of these companies that you deal with, not just OTC, but maybe even on a bigger boards. A takeaway from the conversation that we had already, talking about the appellate process, or again, things to look out for as they are involved with some of these companies. What's a good takeaway that you can give folks within the last 10 minutes here?
Yeah, I think to circle back a little bit about what you were saying with diligence. I think diligence is important. I think that a majority of what I read on Twitter is opinions
Emotion.
that are on emotional opinions that
Yeah.
are based on very small details. And I don't fault these people whatsoever, because it's easy to be in a position
Good point. Good point.
where you don't know everything, and have an emotional response. And I completely understand how things might look from certain positions, but in the same token, I do hope that they understand that attorneys, my clients, no one's out to do the wrong thing. And although I know, I've seen comments about, fees and XYZ and shareholder value and things like that. And I completely understand those kinds of concerns, but it's beyond, it's beyond sometimes what they might, what people might see on the surface. 10Ks are hundreds of pages, and an opinion based on 3 lines is or decisions that are made based on 3 lines, or 3 lines and a couple tweets that you saw about something else, sometimes aren't fully informed decisions. So I think that if if anything should be taken away, I think the more you know, the better, and you'll never know everything.
The
So
more you know, I'm gonna put that on a T-shirt. That might be the next shirt. Now, okay, see, so here we go. We kind of chastise a person a little bit. So first of all, appreciate that statement right there. They made a little off color remark, but now they come in with a question, uh, which is actually a good question. So appreciate you, and we are going to be glass half full as opposed to glass half empty, and we are going to be reciprocative. That's not even a word. I'm making up Latin words now of all inquiries, and we'll bring this up. Will an E10 filing need to be filled out before the GSD vote in a week? And if you can't answer that, great. But if you can't, okay, also okay. But can you get some clarity in terms of what that is, so no one's assuming what is meant by Kemia's number one fan's question?
so I'm not going to comment on that.
Okay.
I that's yeah, I can't comment on
Okay.
any of that.
Awesome. Awesome.
There's a lot of public information regarding that company and the business that company is doing. So I encourage everyone to look into it and carefully look at what's being done.
I think that could be even though we had a great discussion talking about appellate court, appellate process, and things like that right there, that statement right there could be the moral of today's session, right? Do your research. You're not going to know
Yeah,
everything, and don't just make emotional conversations and start emotional dialogue, but make sure you have some fact. A lot of the stuff about these cases, about these trials, about these companies is obviously within the public domain. So go out there and do that research, and then come to the table with a valid concern or valid question before, again, just flying off the handle or whatever. Not saying anyone here is flying off the handle, but again, be more
right.
factual as opposed to only emotional when it comes to dealing with somebody's situation. And that, I'm going to say, is a takeaway for this particular conversation. So, Dr. Pazanantes, I'm giving you the doctor. It's no longer just Esquire. It's no longer just partner. Mark, if you're listening, we need to make this man a doctor. Um, I appreciate you. We appreciate you for the session. Appreciate having these premium exclusive conversations with you and your team. Like the fact that we can continue to have them. And community, please engage and interject. What are the subject matters that you want to have as we continue to have this? We'll do this on a monthly basis. What is it? The third Thursday of each month. So send me a DM. I know you know Gus's Twitter. You're sending him DMs as well. So go ahead and do that. This last question, and then we'll close, man, from real easy, just because I love his name. What are the fiduciary responsibilities as a lawyer to a client? And where are the gray areas, and what are the leading industry practices? Man, hold on. That could be next month's right there. that right there could be next month's conversation, to be honest. But I'll let you start with it.
Fiduciary responsibilities, they're just traditional fiduciary responsibilities. Duty of care, duty of loyalty. Um, Gray areas and what are leading industry practices. I'm not sure what that means. Uh, by gray, I guess when those duties are breached, that'll always be gray forever because no two scenarios are ever going to be the same.
Mm.
Leading industry practices, I don't know what that's referencing. But yeah, the fiduciary responsibilities, it's very similar to like an officer or CEO or director, that those positions in a company have to their shareholders.
Okay. Do your job.
Obviously,
Do your job, and
yeah,
don't waver, and make sure you do what's best for you, the customer, the client, and
right,
what's legal.
exactly.
I'm just breaking it down in the layman's terms, right? Because I don't have all the acronyms at the end of my. I've got a couple, but not the. Gus, man, I appreciate you. Listen, thank you again for the time. Thank you to the community for engaging with some quality questions, and again, let's come up with some good discussion for next month as well. I think this conversation around the appellate process, the ins and the outs, and kind of that 200 to 300 level kind of deepness that you went in today was valuable. And listen, let's continue to have a good time. And again, congratulations on the promotion and everything that you do.
Thanks, James. Always a pleasure.
Appreciate you, brother.